Welcome once again to Leto's Law. Here's Steve Leto.
That story about the Beverly Hills safe deposit boxes and the FBI keeps rolling on, and every time it pops up in the news, I get a lot of people asking me to do updates on it. Got quite a few requests on this one. And the Washington Examiner ran a story, and then also the LA Times ran a story very, very recently. The LA Times has actually been the one that's staying on top of this the most actively. But recently, federal authorities cash in on safety deposit box seizures as owners fight back. And so the story I'm going to give you first is from the Washington Examiner. Barnini Chakraborty wrote it. Married couple Jenny Pearsons and Michael Storr are not wealthy. They are not wealthy. Pearsons works at a nonprofit theater in Los Angeles, and Storr is a transportation coordinator in the film industry. Couple have been saving for retirement for years. They invest in silver, and they did that when they could invest it. And to keep that property safe, they didn't leave it in their home. They rented a safe deposit box at U.S. Private Vaults, the one we've been hearing about in the news. They thought everything was above board until news broke earlier this year about a raid at that business in Beverly Hills. The government alleged that the company conspired with customers to sell drugs, launder money, and stash ill-gotten goods. But the original accusation was against the company that rented out the boxes. So the government went after the company renting the boxes, but along the way grabbed the boxes. They had a warrant, and FBI and DEA agents spent 5 days ripping several hundred safe deposit boxes out of the walls and laying claim to the boxes and their contents. Prosecutors argued they were within their rights, that the boxes contained weapons and drugs, but they also took jewelry, precious metals like silver, money like cash, and they took it all to an undisclosed warehouse. And they say the final haul was worth about $86 million collectively from all those boxes. The problem is that the federal authorities took the items from people who have not been accused of a crime, including Pearsons and Storr, the couple we talked about above, who were buying silver as a long-term investment for their retirement. Now, the government's been able to keep all this stuff so far because of the vague standards of civil asset forfeiture. That allows the government to seize property and assets without any actual evidence of criminal wrongdoing. And in essence, you've got to prove your stuff is innocent to get it back, as opposed to them proving you've done something wrong. During the raid, authorities also seized a man named Joseph Ruiz's life savings. He was an unemployed chef, and he had $57,000 in a safe deposit box. Prosecutors argued he couldn't possibly have made or saved that much money, and they accused him of being a drug dealer. Now, he went back to court and got his money back. He actually won. And the government dropped his case against him after he proved through documentation that he had sources for the money that was legitimate. And he told the LA Times it was a complete violation of my privacy, and they tried to discredit my character. Now, he is one of 800 people whose money and property were taken in the raid back in March this year. 6 months later, the U.S. Attorney's Office in Los Angeles has not been able to prove criminal wrongdoing by the majority of box holders whose belongings the government is actively trying to keep. Now, there have been many court documents filed by many different people, and an investigation by the LA Times shows the government's reasons for taking money and property from the other people were just as flimsy as those they used to try to argue and say that they had the right to Ruiz's money. Agents claim that drug-sniffing dogs alerted them to the scent of narcotics on the seized cash, but as everyone knows, drug-sniffing dogs are about the same as flipping a coin. That's what Radley Belko wrote in the Washington Post a while back. While dogs are indeed capable of sniffing out illicit drugs, they've also been trained to please their handlers. And even drug dogs with conscientious handlers will read their handlers' unintentional body language and alert accordingly. And as many people have noted, much currency in America in circulation already has traces of drugs on it simply by going through all the different hands it's gone through before it got into your pocket. Federal authorities have also pointed out that some of the people here used rubber bands to keep their stacks of cash together. And apparently, rubber banding money is what money launderers do and drug traffickers. And so if you've ever put a rubber band around your money, you may want to think twice about that, because that's an indication that you could be violating some laws there. And if they catch that cash in their possession, they might keep it, saying, well, you're obviously a money launderer or a drug dealer. Why else would you use rubber bands around your money? The government also said in court documents that it deposited all the seized money in a bank, which experts say would make it impossible now to test which drugs may have come in contact with which bills. And even though U.S. Private Vaults was indicted in February on charges of conspiring with unnamed customers to break the law, no one has been charged. A criminal case against them hasn't moved forward, and the U.S. Attorney's Office in Los Angeles isn't saying why. Unfortunately for the box holders, though, in civil forfeiture cases, the stuff of yours and you, by association, are considered guilty until you prove yourself innocent. No criminal conviction is required. The government only has to show that it's more likely than not that the money or property taken was linked to illegal activity. And quite frankly, the burden is on you to prove it, not them. That's the crazy part. So civil forfeiture was initially used as a tool against large-scale criminal enterprises, but it's been widely abused, as covered in the media and places like my channel, where I talk about it seemingly all the time. For Pearsons and Storr, the government's seizure of their silver is unacceptable, and they've decided to fight back. They, along with 6 others, have teamed up with the Institute for Justice for a class action lawsuit challenging the government's raid as an illegal search. The government's theory is that having cash makes you a presumptive criminal, and I think every American should be worried about that, says Rob Johnson, who is a senior attorney at the Institute for Justice. And just so you understand all of this, I went and grabbed a portion of a story by Michael Finnegan of the LA Times that came out recently. And he points out that looming over all of this is the possibility that a judge will grant the box holder's request for a ruling that the entire raid was unconstitutional. So remember, they had a warrant that said you can go in and seize the business's assets. And yes, the business owns the boxes, but it does not own what's inside those boxes. And the warrant made that distinction. And it looks like the agents got a little overzealous. And so if the judge were to rule that the entire seizure was wrong, it would jeopardize prosecutors' ability to use any evidence seized from the safe deposit boxes in both forfeiture or criminal cases. In warrants authorizing the search and seizure of all business equipment at U.S. private vaults, the magistrate placed strict limits on the government, explicitly barring federal agents from searching the contents of each box for evidence of criminal wrongdoing. In the warrant application submitted by an assistant U.S. attorney, a statement by FBI agent Lynn Zellhart assured the magistrate that agents' inspection of each box would extend no further than necessary to determine ownership, so that belongings could be returned once the government took an inventory of the property seized. Box holders' lawsuits allege that those promises were false, they've certainly been broken, and that agents with no probable cause intended from the start to rummage through the boxes looking for evidence in a criminal investigation, if not just civil asset forfeiture, to take it all. So Jane Bombauer, a law professor at the University of Arizona, said that under the restrictions that the magistrate imposed on the search, the use of drug dogs to sniff the cash inside the boxes was a Fourth Amendment violation. Getting back to the very beginning of this story, there's a place that runs private safe deposit boxes that is not a bank, okay? And there's companies that do this stuff. You can rent like the equivalent of a P.O. box and now a safe deposit box. You go in, you put your stuff in, you pay rent to the landlord who owns the boxes. The government claimed that they had evidence that the owner of this company was conducting criminal actions on the premises with this business. So they went to a magistrate and said, we want to get a warrant to go in and seize the stuff from this company that's doing criminal stuff. And the court said, yes, you can, but the court recognized that there were safe deposit boxes rented by other people that contained stuff that belonged to other people. So the stuff in the boxes does not belong to the business owner. And so here's the issue. The box nest that the boxes all go into is part of the business equipment on the premises. And so they said, we need to seize those boxes and that nest because it's all part of the same criminal enterprise. And the judge, the magistrate, actually said that you cannot search those boxes. All you can do is take the contents out, in essence, and catalog it and return it to the rightful owners. And it looks like the federal agents knew, well, once we open the box up and see what's in there, we can't ignore what we found if it's evidence of further crimes. And they're making the argument that they found cash, and cash is evidence of a crime. So a lot of people responded to my last video where I mentioned this. They said, I would go nuts if I was that magistrate, knowing that they violated the terms of that warrant after they promised not to do what they actually just went and did. And I would too. I would too. And it'll be interesting to see when that particular point gets litigated, because the warrant says specifically you can do this, but you cannot do this. They did this and they did this. So now they've gone to court and said, because they did this, they're out of line. And if the judge rules on that in favor of the box holders, pretty much all this goes out the window. But it's a really, really weird situation. And a lot of civil asset forfeiture cases don't get fought because the amount of money is not enough to fight over. So they pull somebody over the side of the road, they've got $800 in cash on them, they take it from them. If you want to sue and get your money back, it'll cost more $800, so most people would write that off as a loss and move on with their life. But here we've got millions of dollars involved in this case, and it belongs to a whole bunch of different people, and all you need is a couple motivated people to bring the case as a class on behalf of everyone else, and you might get a ruling that covers everybody. It would upset me greatly if my stuff had been seized, okay, and I would do something about it as well. But we'll see what happens. This case has been going on now for some time, and it looks like it might come to a head soon. I hope it does. But federal authorities cash in on safety box seizures as owners fight back. And that's from the Washington Examiner. And like I said, I also quoted some stuff here from the Los Angeles Times by Michael Finnegan, who's been following this story very closely. People who tipped me off to it were Josh, Andrew, Frizzell, Chris, Lloyd, Harriet, Jonathan, Adam, Steve, not me, Michael, and two Davids. Thank you very much, people. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Leto's Law. Success is not the key to happiness. Happiness is the key to success.